Good evening, everyone. Thank you for joining us for another session of Forbes India's Disrupting the Discourse. Today, we'll have a discussion about what the traceability requirement in the newly notified intermediary rules means for privacy and for security. Ever since the traceability requirement was introduced in the 2018 draft intermediary guidelines, the concept has raised multiple questions about whether or not it will break end-to-end encryption and thus undermine all users' privacy and security. Since the rules were notified, Facebook and WhatsApp have even filed two separate petitions against the Indian government over the traceability requirement. For today's edition, we have with us Dr. Amar Patnaik, who's a Rajya Sabha MP from Biju Janata Dal, and also a member of the Joint Parliamentary Committee on the Personal Data Protection Bill 2019. He was also a member of the ad hoc Rajya Sabha committee that had recommended breaking end-to-end encryption to trace distributors of child sexual abuse material. We also have with us Mr. Arvind, a senior advocate who has represented WhatsApp in the Madras High Court and the Supreme Court in the WhatsApp traceability case, and is currently representing the platform in the privacy and competition cases against its new privacy policy. We also have Dr. Debayan Gupta, an assistant professor of computer science at Ashoka University, where he focuses on secure computation, cryptography, and privacy, and Ms. Namrata Maheshwari, the encryption policy fellow at Access Now. A lawyer, she's also a consultant with Washington, D.C.-based Center for Democracy and Technology and is involved with the Global Encryption Coalition. If you have any questions during the panel discussion, feel free to ask them on Twitter or Instagram using the hashtag AskForbesIndia, and we'll try to bring them up. So first things first, Mr. Datar, how well do you think these regulations have been drafted? And are these actually implementable specifically with respect to the traceability requirement?
I think the regulations are seriously open to challenge. It is unfortunate that such far-reaching regulations are appearing in the rules rather than in parliamentary legislation. For example, here we are discussing the issue of traceability, and we talk of the need of every significant social media messaging service to identify the first originator. Now, the word first originator is not defined in the rules. In fact, the Act only talks of the originator. And ironically, the definition of originator excludes an intermediary. So you have the paradox where the Parent Act excludes an intermediary from the definition of an originator, but you have the rules which say that a social service, social media intermediary must enable the identification of the first originator. There are other serious challenges which I can't go into too much in detail because of time shortages. My other worry is that this far-reaching thing has been passed for what? That the first proviso says is primarily because to enable crime detection, because the proviso says that the order for traceability will be passed to prevent, detect, investigate, prosecute, or punish offenses of a serious nature, where the minimum punishment is 5 years. Now, I don't know whether any study has been carried out that these offenses, the investigation of these offenses were hampered because of lack of traceability. There is no evidence, there is no data, nothing of the kind. There are other serious problems. If you say that you have to enable the first originator of the information, does it mean that the social messaging services store this information in some database? If yes, then how long do they store it? Because once the offense is punishable for 5 years, then there is no limitation. Under 468 of the Criminal Procedure Code, the investigation can start much later, the offense can start much later. There is no limitation period as such. So suppose after 2 years you said, tell me that, look, there was some kind of a offense against sovereignty of India or rape or something like that, and give me the first originator. How does the party, I think? And I don't know if these things, rules, before they were framed, at least they could have put out the draft rules, got the feedback from the concerned parties. And finally, just to cut a long story short, how many countries in the world have mandated traceability for social messaging service? I don't know. I don't know of any details of such. So there are serious issues on this Rule 4, Sub-Rule 2, which deals with traceability. And apart from legality, it's going to be very, very difficult to implement. There are serious issues whether it will break the end-to-end encryption and other issues, but that's a matter pending in court, so I don't want to get into that. But I personally feel the rules are not only badly drafted, but they're seriously open to challenge.
Thank you, Mr. Datar. You raised some really interesting points, at least with respect to one of the things you raised about how in the first proviso, there's talk about these are supposed to help with, in relation with rape, sexually explicit material, or child sexual abuse material. Here, I'd like to ask Dr. Patnaik, who was part of the ad hoc committee that actually recommended that law enforcement agencies should be allowed to break end-to-end encryption when it comes to tracing distributors of CSAM, that's child sexual abuse materials. So if you can walk us through what was the thought process there, what kind of submissions were made, what kind of evidence was presented to show that traceability would help?
See, I would deal with this entire thing, including the question that you asked, at two levels. One is conceptually, whether it is necessary to have this kind of legislation. And second one is the question of technically implementable or not. Now, if you look at the first part, and specifically with reference to the question relating to CSAM, imagine the situation in which the social media intermediary or social media messaging was not resorted to, but a simple telephone calls or telephone services were used. In which case, during a normal investigation, the investigating officer would ask for the call records from the service provider. And we all know that these call records are not stored indefinitely. They are also stored for a fixed period of time. So the law enforcement agencies ultimately, in their duty to go to the root of the matter and identify the actual perpetrator, they are doing what is required of them to do as per law. They are not guided by, or they are not restricted by the limitations of the telephone service provider, or whether it is whether they have technically they do not have a server of that capacity. So now these are two separate issues. So similarly, on the point of view of having the guidelines for social media, significant social media intermediaries, I can tell you this, that even in the privacy law, which is at an advanced stage of discussion and discussion rather in the Joint Parliamentary Committee, many of these issues were also discussed. Now, as regards provision relating to regulation of significant social intermediaries, you will find in Section 26 over there of the bill a narrative as to there is some kind of regulation that has been thought of, and that has to be brought in through, again, that has to be kind of amplified through the Data Protection Authority bringing in the regulations, code of practice, many things. Here, I agree to a limited extent that this thing which has come out under the IT Act as a part of the thing mixes probably both these aspects relating to the IT Act and relating to privacy. And maybe as a reaction to, even the Supreme Court have been saying that you have to bring in regulation, they have to do self-regulation. So it has probably become a little complex because of that. Once the main act comes, which is the Personal Data Protection Act, I have a feeling that other things will have to align itself, because the overarching authority over there will be the Data Protection Authority to ensure that citizens' data is protected. As far as CSAM is concerned, to breaking the end-to-end encryption, the thought process was that ultimately it is a serious crime, very grievous in nature, and the deep wave it even continues. Despite all those regulations, it may still happen, and therefore our concern should only be to get at the people who are involved in this process. Now, it will be for the service providers to ensure through an alternate protocol of encryption, or whether to do it within the existing codes, protocol or architecture to provide that information. Because ultimately, I think the ends of justice will be served only when that particular case is solved, and not by protecting the rights of the person who has actually perpetrated that crime.
So you have raised a number of points, and one of them is that the Personal Data Protection Act, whenever it is notified, whenever it is passed, will be the one that will govern the intermediaries. My understanding was that the intermediary guidelines that have now been notified were supposed to deal with the traceability question, which is what was repeatedly said in the Madras High Court as well as in the Supreme Court, that WhatsApp will await instructions and act accordingly after those guidelines are notified. So would you, the Personal Data Protection Bill / Act was never even on the table, if you would want to talk about that.
True, as I said, the Act and the Personal Data Protection Bill flowing out of the Swami judgment, and it has taken some amount of time, whereas the IT Act was there in 2000, and the intermediary guidelines were first in 2011, then they were put up for the draft were there in 2018. So it has gone to the intermediary guidelines flowing out of the IT Act have gone through have a much more kind of history behind it compared to the Personal Data Protection Bill. But the way Personal Data Protection Bill sections have been structured and the definitions have been given, and you will see when the final shape of the things bill comes after discussion of, you would agree that we spent one full year discussing with all kinds of stakeholders. It is a very comprehensive piece of legislation, and despite that, I'm once again reiterating that it will be also having regulations, it will also be having rules, and then I have a feeling that a number of things would get subsumed over there and would be the right place where they should be featuring, considering the purpose to be achieved, the statement of the object which is there in the Personal Data Protection Bill. The IT rules, the Section 69, Section 79, all the IT provisions, in fact, would require a revisit. And in case there is a discrepancy in any of the acts, including the IT Act or the Competition Act or the Consumer Protection Act, the new act has come. It is very clearly mentioned in the, or thought of in the Personal Data Protection Bill, that it will be the Personal Data Protection Bill that will be the umbrella legislation for this. So I think a number of these issues would get addressed. And what is now currently happening are transition kind of a reaction and rules, and that has to be also there because the PDP bill is taking some time.
Okay. Thank you, sir. It's interesting that you mentioned the Parent Act under which these guidelines were notified, because it is my understanding that the Information Technology Act is currently undergoing amendment. There have been meetings within the ministry to that effect, maybe to bring it at par with the Personal Data Protection Bill as well as the new intermediary guidelines. Sir, but there's one point that Mr. Datar also raised, which was about data minimization. That once you enable traceability, you have to store all the excessive data for posterity. And even the Personal Data Protection Bill, at least the version that has been made public, has constraints around data minimization. Data minimization is a principle it sticks to. So do you think it's violative of what is already out there? The traceability requirement?
Data minimization, proportionality, and storage limitation, all these are principles on which the privacy law is centered around. But the overall objective is to achieve the citizen's privacy by taking his consent, but also agreeing to the fact, which is there in the fundamental rights itself, is that there are reasonable restrictions. So these reasonable restrictions have been put in at different places. So how much of data minimization is required would still be circumscribed by the overall requirement of achieving the ends of justice that we have to remember.
To comment on what the traceability requirement means for privacy and security of users, and if it means the proportionality standard laid down in the Puttaswamy judgments, both of them.
The rule 4.2 even now says that it will be subjected to judicial scrutiny, and only based on that order. And the judicial scrutiny will not happen in vacuum. It will be guided by these principles which have been set down in the Puttaswamy judgment. I'm sure of that.
Right, sir. So, but even when it comes to 4.2, it's not just judicial scrutiny. Judicial scrutiny is one of the options. The other is executive oversight. But Namrata, one sec. I think we lost you. Namrata, am I audible?
I'm here. Yes, I can hear you.
Yes. So I was asking you, what does the traceability requirement mean for privacy, especially in light of what Dr. Patnaik as well as Mr. Datar pointed out from different ends of the spectrum, so to say?
Right. So I think there are two big questions that we need to look at when we analyze the traceability mandate. One is to what effect and at what cost. In terms of effectiveness, I have my doubts about whether this mandate will in fact achieve any of the stated goals. Some of the preliminary reasons for this are that one is it is very vulnerable to manipulation. Second is that the malicious actors that you're trying to catch will simply shift to another platform or create their own. There are several tutorials on YouTube to make end-to-end encrypted platforms. So in that sense, arriving at the person that you're trying to arrive at will probably not happen through this model anyway. The third is, unless I share the particular message simply by forwarding it through any other means, if I share it using the share icon, or if I share it from my gallery, or if I take a screenshot and share it, the entire chain changes and the originator changes. So there are several doubts as to the efficacy of this model, which then goes back to what are the costs at which you're trying to implement this model. And the costs, like Mr. Datar pointed out, in end-to-end encrypted platforms will have to track every single message that every user sends on that platform and retain that data indefinitely, because they don't know what message could potentially become subject of investigation. And this is hugely problematic because for the mere possibility of identifying a few miscreants online, this rule essentially puts at risk the privacy and free speech of all the users on the platform, which runs into billions. This is disproportionate. I agree with Dr. Patnaik that fundamental rights come with a set of reasonable restrictions, but in light of the Supreme Court judgment on the right to privacy, the grounds on which such restrictions can be imposed are that it has to be done lawfully, which, as was pointed out earlier, it has to happen through a legislation with parliamentary scrutiny, public consultation. This cannot happen through executive rulemaking. Second is proportionality, which I touched upon. It's going to do more harm than it's going to do good for the end user. People use these platforms, especially during the pandemic, to have private conversations with friends and family, for doctors to talk to their patients, for lawyers to talk to their clients, for journalists to talk to their sources, and so on. And finally, necessity, right? You need to have effective safeguards in place. You need to have prior judicial review if such an order is going to pass. But Rule 4.2 provides also for orders passed by government agencies, not just by the court, to impose traceability. And I know that the offline context is often brought into the picture, that even in the offline spaces, there are limits to privacy, which is true. But in the offline space, to a great degree, you have guarantees of secure spaces for communication, and end-to-end encryption makes that possible in an online environment where otherwise how much data is generated, how much data is accessed, and how much data is stored. There are several blurred lines around those things. So it's particularly important to protect those spaces online. And as far as investigations and law enforcement access is concerned, even in the offline space, 100% of the evidence available is never available to law enforcement all the time, because doing so is simply impossible or would violate too many rights. And I think that's something that we need to think about in the context of the traceability mandate.
Right. Namrata, this is something that Mr. Datar also mentioned, which is the problem of definitions. And everyone I've spoken to also talks about it. So when we talk about messaging services, have those been defined anywhere, either in the delegated legislation, which is the rules, or in the Parent Act?
Actually, in the Parent Act, the definition of intermediaries is very, very wide. So it covers all kinds of...
Namrata, I don't mean intermediaries. I mean messaging services, because that's how WhatsApp, Signal, Telegram, etc., get affected under the Rule 4.2, the traceability requirement, because it's significant social media intermediaries, primarily in the business of, primarily in the nature of messaging. So is there a definition for messaging?
Right. So that is what I'm coming to. I think there are two messaging services come under the larger category of intermediaries, which is under the IT Act. And then the rules have created a new category called the significant social media intermediaries. And within that, Rule 4.2 creates a separate kind of mandate for these messaging platforms. The messaging platforms, there's no clear definition. I know that different intermediaries or different messaging platforms like WhatsApp, like Signal, are interpreting the rules in the best way they deem fit. But there's also the question of where the definition of intermediaries becomes important is because under the Act, most of these intermediaries, including messaging platforms, want to be identified as intermediaries because it gives them safe harbor protection, which is protection from liability against third-party content. But now there is the question of trying to carve themselves out of this social significant intermediary definition or messaging services interpretation because they need to save themselves from having to comply with such an onerous mandate. So I think that's going to be interesting to see, but there is no clarity on exactly which kind of messaging platforms will fall under the traceability mandate.
So the argument, for instance, that Facebook put forth in its lawsuit is that it's not primarily in the service of messaging, given that it's a public platform, unlike WhatsApp, which is a messaging platform. So does this affect email services as well?
It might, and I think it would also affect operating system service providers who also provide a separate messaging services. Similarly, it will also affect platforms that we use within corporations or within workplaces to communicate internally. So I think that argument, like you mentioned, is going to come down to what is interpreted as the primary purpose of that platform.
Mm-hmm.
And with email, I'll just add to that. With email, I think the issue is also that you cannot as openly have groups on that platform as you can on messaging platforms. So it wouldn't be comparing apples to apples, even if it is considered to be within this definition. It's not the same as an end-to-end encrypted messaging platform like Signal or WhatsApp.
If I may bring in Dr. Gupta here, what would happen to end-to-end encrypted email services or protocols such as PGP or services such as Tutanota or Proton Mail? Of course, right now in India, they do not have more than 50 lakh users, therefore they aren't significant. But the entire aim of any social media intermediary would be to have as many users as possible. So how would these rules affect them?
So obviously, I'm not a lawyer. I can't give you the details about how exactly they would affect them legally, but I can tell you how they would affect them technically. Currently, end-to-end encryption does not work. It breaks if you bring in traceability. So first of all, I'll use a couple of metaphors. I like to stay away from metaphors because they sometimes cloud more than illuminate, but I'll have to do that because otherwise I'll just be talking in math. I think there are two problems that we need to understand before we get into any of this. One is the problem of having a global system under which you're trying to do local regulation. We have the same problem if you have a global monetary system and you have local regulation, you end up with tax havens. Similarly, when you have a global system, our only planetary scale achievement really, other than global warming, the internet, and you're trying to locally regulate it, you're going to end up with a lot of trouble. As one of the people was saying earlier, your definitions start breaking down. First originator. What does that mean? First originator in the territory of India? How does WhatsApp know who's in the territory of India? They're not tracking people's locations. +91 number. I know a bunch of people in the UK who've kept +91 numbers. Can you imagine what would happen if a German citizen who happened to have a +91 number because of previous whatever reasons, sentimental reasons, was traced? I can see a German constitutional court getting extremely angry about that. The problem is these are global setups, right? And that comes down to this discussion that multiple people brought up about having reasonable restrictions. So here's the problem. We are not talking about the laws of a country here, right? WhatsApp or Signal or anyone else, the reason they cannot share their material, the reason they do not have backdoors is not because they've signed a contract saying we will not give out the material. That's not how it works, right? Our legal systems normally are retributive. A law against murder doesn't prevent murder. It says if you get caught committing murder, now you're in trouble. These systems operate on the laws of mathematics, which are preventative, right? Those laws you can't have reasonable restrictions on. Either parallel lines meet or they don't. You can't play around with that, right? Now, the end-to-end encrypted systems that we have today are the result of decades of research. These are not million-dollar problems. These are not billion-dollar problems. These are worth much, much, much more. There's a lot of research that has gone into it over many, many decades. Now, the problem is, let's say I have this beautiful geometric proof. I use all the axioms from Euclid and you build up this wonderful proof and I build a bridge using that. And now you come along and now you tell me, okay, I want a tiny edit, 0.1% of the time. Can you just have parallel lines meet? Now it sounds very small, but I can't do that. The moment I change that axiom, I don't know whether anything works anymore. I have to rework all the proofs, everything from the ground up, right? So it's not a question about any single protocol. The problem is the mathematical systems assume certain things. For example, indistinguishability of ciphertext. That is, if I send you a message A versus a message B, nobody in the world outside of you and me should be able to know which one I sent. Especially platforms like Signal also have something called OTR, which prevents you from proving to someone else which one I sent. Essentially, it allows you to forward the message yourself after you're sure that I sent it. So there are all of these things that are problematic at a sort of very basic definitional level. The second problem with any kind of backdoor or traceability issue is you can't do it for one person, right? Because these systems are global and because mathematics is not just global but truly universal, you can't say that only the Indian government will have access to X. If India has access, so does China, so does UK, so does Australia, so does everybody else. There's no way to prevent that. The way to prevent it in some sense would be having a key that rests with the Indian government in some form or fashion. Now, imagine having that key. There's a reason why platforms like WhatsApp and everyone else decided to wash their hands of this problem. Because the moment you have that, the moment you have those back-end keys, those become prime targets for hackers, right? If I can listen into Ratan Tata's conversations and figure out when to short the stock, etc., that's huge amounts of value, right? So like you have to be very, very, very careful about who has that key. Given that, the US government appears to have, F-35 Mark II Lightning plans hacked, Office of Personnel Management, SF-86, its own security forms for security clearance hacked, JP Morgan Chase, biggest bank, one of the largest banks in the world, hacked. Like just a few days ago, I found my home address on Domino's, right? Leaked to the world, right? So we cannot afford to leak security in that way. Now, I will give you a couple of caveats on this. First of all, I think there is a lot of middle ground here, which needs to be negotiated. I don't think that, I know some of the people on both sides of the story, and I know the government aren't idiots. They're not doing this for fun. I think part of it, I suspect it is the government trying to push the needle on the matter, saying, hey, social media people, you've been ignoring us for so long, now find some solutions. And then there's probably some sort of negotiation that's going to happen. But in its current form, what the rules ask for are mathematically untenable. There's no legal argument to be made that just doesn't work. Unless, of course, unless you say you don't want guarantees, right? Unless you say we don't care if a criminal has a side-loaded version of WhatsApp, and so I can pretend that, Aditi sent that message instead of Debayan sending that message. If you don't care about that, if you don't care about people lying, then sure, you can have anything you want. But any kind of security guarantees, not going to happen.
Right. So if I may go to Mr. Datar here, Dr. Gupta has pointed out that mathematically it is impossible to introduce traceability without breaking encryption. You break the entire model. And that's also been WhatsApp's stance all this while. Signal has also said that, which is the underlying protocol. But there's also a very genuine state need to get to the originator. So how do you balance that genuine state law enforcement need to get to the originator of someone who's spreading disinformation about minorities, and that leads to their lynching, or it causes the suicide of a young woman who's been maligned publicly and lives in a conservative society, or as Dr. Patnaik also pointed out, there's CSAM. How do we balance the two?
Yes, there we come to the question of proportionality. No doubt that these are horrendous crimes, and it is essential that we use every possible method to trace the perpetrator of the crime, the originator of the crime. Now, what I've been repeatedly saying is that in the process of, we're now talking of crime investigation. Okay, as far as prevention is concerned or detection is concerned, maybe this originator is not going to help. Yeah, detection maybe, but as far as prevention is concerned, I don't know what's the rule. Dr. Gupta rightly mentioned that traceability may be incompatible with end-to-end encryption. He says mathematically it cannot work. He's a technical expert. I don't know, but I perfectly understand his concerns. Your question is, there is a social need. There are serious criminal issues. Will not some kind of duty or obligation on the social intermediaries be necessary to investigate these crimes? My first question is, before you do this, there is an old Hayden's rule which is 400 years old. They say that what is the mischief you're trying to prevent? You're trying to detect crime, trying to investigate crime. Now, what I'm asking is that will traceability help in any way? Is there any study conducted? You have got crimes, say, of what we call CP and RGR in Supreme Court in the Prajwala case. We called it child pornography and rape, gang rape. So the usual phrase is CP and RGR. Let's take CP and RGR. And in the Madras High Court, that was what first started off. There was some kind of horrendous gang rape in some southern district of Pollachi or something. And then this came, that case had nothing to do with traceability. That case had some absurd prayer that you can't use WhatsApp without an Aadhaar card. That was the origin of the case. And then somebody brought up this thing and said that, look, this message went viral on WhatsApp or went viral on some social media. Therefore, we must find out where did it start. Now, and this has taken up and it has come into a rule. As you rightly put it, before you draft such rules, why don't you first find out, A, is it technically feasible? Secondly, if its traceability was the key to solving crimes, you think the United States would not have done it, Japan would not have done it, Germany would not have done it? I'm not saying that we should not be the first person in the world, but before you put up such radical solutions, have you at least tested it? It's very easy to say, yes, fundamental rights are subject to restriction. Yes, of course, I know fundamental is subject to restrictions. But what kind of restrictions? And what are you doing? You're saying that you must identify the first originator. Your act also doesn't require that. Where's the question of the rule requiring that? There are so many other limitations. And as far as these crimes are concerned, there are stringent provisions in the Information Technology Act itself, Section 69A and so on, which provide for all these punishments. See, what I'm saying is, one is the imposition of a duty, and what is the cost? To give a metaphor, I mean, it's, with the classical thing of finding a needle in a haystack. Because you want to find a needle in a haystack, you want the person to label every piece of straw in that huge truck so that you may be able to trace one needle in that haystack. Is that practically possible? Suppose WhatsApp gets about 100, let's say social media messages, significant media messages, about 500 million messages are sent every day up and down. And when you talk of first originator, what message do I store? I send a message to you. You send it to the Supreme Court Bar Association. From there, it goes to 4,000 members. Now, are you going to, and those 4,000 send to another 10,000? And that 11,000th man does something and you want to trace it to me. Can you imagine the kind of storage you're talking of? I mean, Dr. Gupta will be a better person to say. We're talking of storing of trillions of messages. What is the cost? What is the thing? And at the end of the day, is it going to help in solving a crime? And suppose you come in 2027 and tell me, look, there was a child rape took place in 2021 and we are now traced it to some person in Chennai or in Madras. I mean, I've still not understood. Dr. Patnaik can throw some light on it. What is the basis for this kind of a law? And I have got serious objections because we have to now really think that we can't have a government by executive notification. These are serious matters which go into your fundamental rights, go into privacy issues, go into other issues. Now, you talk of the crime. What about my messages? I don't want them to be stored endlessly just because one crime will be detected later. So these are all matters to be taken up in Parliament. There has to be a parliamentary committee. They must debate it. They must call for evidence from different people. and then pass a law, not by notifications which provide punishment and so on and so forth. There's a role of Parliament and there's a role of the executive. The lines are getting, unfortunately, very, very blurred.
Right. Dr. Patnaik, if you'd like to respond to Mr. Datar.
I think we'll have to take a call as to whether technology would subserve law or law will subserve technology. One. Then number two, we will have to also be clear that rules are not executive instructions. The rules come before the Parliamentary Subordinate Committee on Legislation. They get discussed there precisely to find out whether they are consistent with the main act or not. Then number three, that if one particular message results in death of 1,000 people because of a misinformation or a disinformation, then the cost is very high, it can't be calculated. Then the fourth point that I want to make is there are laws, there are provisions in the Personal Data Protection Bill, which is, I would say, again, work in progress, talking about erasure, talking about right to be forgotten, many of these provisions which are in the EU GDPR. And it is also a fact that countries like Australia, countries like Singapore are coming out with this question of traceability, that for crime detection. So I think these are also facts which have to be taken on board. I would only rest by saying that we have to definitely, when any social media intermediary or anybody operates in the country, in India, then it has to be abide by the law of the land. And if the law requires that this is the information to be given, then it has to be given. But just because technology cannot give such kind of a situation, and then we cannot say that the law has to be changed. This is a very kind of a warped argument. And during the discussion, deposition, since the CSAM report has already been given, so I can part with the discussions. The NCPC are very clearly said that in many of the cases, they are unable to proceed further because of lack of evidence or lack of information about the people who have started this entire process. And they are also very clear that despite bringing many of these regulations, it would still continue because the dark web, the things that happen over there, or in the virtual private networks that happens there, so which is not amenable to easy regulation. So I think conceptually, as I started, I think all of us have to agree that we need to have regulation. We need to aid the for a person whose daughter or a sister has gone through the process, let us say, unfortunate process of CSAM. I think for that particular person, safeguarding that person's rights, if it is required to break the privacy of hundreds and thousands of people, I think that's what the law would require also us to do.
Mr. Datar, I believe you have a question.
I just wanted to ask Mr. Patnaik, if the PDP bill is in the advanced stage, what was the need for having these far-reaching rules in advance? We could have waited for the bill to come. The bill could have been placed before the House. Usually in a parliamentary committee, I've given evidence before 4 committees. You could have called for experts like Dr. Gupta, people from IIT or other countries and so on and so forth. So if the bill was in progress, what was the need for these far-reaching guidelines to be announced in advance of the bill?
So you are right in the sense, what was the need, the timing. But if you look at these rules have been framed under the IT Act. And these rules have not been framed under the PDP naturally because it's not an act as yet. But as you would see, as things progress, then there will be a lot of marriage of concepts and implementation in both these acts. Why the timing? Why now? Currently, there is nothing. Currently, there is no regulation. Maybe that is the reason the government has come out with this. I cannot actually be speaking about what the government has in mind or why did it do it. But I can see that since there was this vacuum, and the reports of the Parliamentary Committee on CSAM was already there on their table, and the report, at least the preliminary report of the PDP, was already also on the government's table. Then whether the rules could have come under the PDP Act or they have come under the IT Act, that's okay. We can always go to the question of whether they should have waited for this, whether the remit of the rules have become more than the IT Act itself, which is a fair, I think that is the only fair argument that I see. I'm not really getting into the question of the merit of those things, which I'm defending, but I'm just saying whether they are going beyond the remit of the Act, they're becoming inconsistent, 69A. Those are questions which have to be decided. But I'm sure they are before the courts, and I also am sure that before the courts could decide, I'm sure we are going to have the PDP final act of the Parliament.
Thank you.
Okay. Namrata, I believe you also wanted to ask something.
Right. So one of the concerns is that intermediaries will be forced to over-comply in the sense that given the flaws of the traceability model and access only to metadata not being enough, they will have to access the content to see the context and then help law enforcement. My question is, there is a proviso in Rule 4.2 which says that intermediaries will not be required to disclose the content. But is this to be interpreted as intermediaries will not be required to access the content as well? There's a difference between not requiring them to disclose and not requiring them to access. So in a scenario where they have to absolutely access content to be of any help at all, will they be exempt? This is just trying to understand the extent of the impact on end-to-end encryption and on users' privacy and free speech.
Mr. Datar, Dr. Patnaik, Dr. Gupta, if you want to answer that.
No, as far as the proviso is concerned, it says you don't have to disclose. She's right. The second proviso says that you don't have to disclose the contents of an electronic message, but then the fact remains that you will get access to the message. What happens is that message may not be disclosed in public, right? And this is what the rule says. Who tomorrow says what prevents the court from saying, please disclose the message or put it in a sealed cup? We don't know. And the other dangerous thing is the second proviso says that you will not ask for originator information if less intrusive means are effective in identifying the originator. Now, what is the safety net? What is the obligation to first exhaust all the means before you come to that? There are so many other loopholes. This time is too short, but there are serious problems in these intermediate guidelines. I mean, may have been enacted with the best of intentions, but they're going to create horrendous problems on the ground.
So that's one of the questions that someone from the audience has also raised, that how can social media intermediaries help law enforcement without enabling traceability? So the least intrusive measures, so to say, what could those look like? Mr. Datar, I think...
yeah, I legally... Yes. The less intrusive means that today what's provided in the Criminal Procedure Code for investigation, that's the less intrusive mean. What else is there apart from that? The entire cybercrime is a different cup of tea altogether. So I thought the less intrusive means is if they can't solve the problem with traditional methods, then they will go for the first originator. But I think Dr. Gupta may be better positioned to do that.
Yeah, that's the point.
Right.
Technical aspects, yeah.
Okay, Dr. Gupta.
Yeah, so I think there's a lot of middle ground. I don't think one can go for just pure traceability or pure this. There's a lot of middle ground there in terms of, I'll just bring up two things. One is whether you're looking at retrospective or prospective surveillance, right? Normally, when I say I want to tap a phone line, I get to listen to future phone calls, not stuff that happened in the past. Here, and WhatsApp themselves have also indicated this, you're talking about sort of not calling a person evil and then listening to their messages, but you're calling a message evil and then trying to find the person, sort of the other way around. And I think that's a problem. Mathematically speaking, prospective systems may actually be possible. I don't know, right? We'd have to properly do research on that. But retrospective systems are almost certainly not going to be possible without being open to massive amounts of abuse. That is, you can't sort of look back at previous things too easily. So I think that differentiation needs to be made about saying, hey, Signal, here's a person whom we know is a bad person. We want to see their future messages. That's a different question. I don't know whether that's an easier one to answer or not. Probably it is an easier one to answer, but that's a different question from I want to look at past messages. The past messages stuff is super duper hard to do. And here I'll just mention one point about something someone said about technology. This is not technology. This is the laws of mathematics and physics, right? It's not, we're not saying, oh, we built something and therefore we want to defend it. No, this is like, one can then say that we don't want E2E. Fair enough, right? If one says, I want a dam, but then I want to be able to make the dam out of transparent material, now we have an engineering problem, right? So it's sort of like that. You can't have E2E then. Then you need to talk and say that, okay, India bans E2E, you're going to need to have some other method of encryption, which do exist, which provides some reasonable amount of security, but does not allow the blanket of E2E. The problem with that is the internationalization aspect. Suppose I'm talking to someone in the US. Suppose I'm talking to someone in Germany. Suppose WhatsApp magically implements the India-specific protocol, satisfies every government measure that is required, right? Who then translates between these two protocols, between Germany and India? Someone in the middle has to sit there, or the protocol has to somehow magically work seamlessly. It's a structural issue. It's the same issue that has happened with financial system. If you have a worldwide system that works seamlessly, that works under the same set of laws, i.e. in this case, mathematical laws, and I completely understand why the government wants to implement sovereign laws on this. You can't have, because if the government doesn't, then in some sense, it's these multinational companies that are wielding sovereign power, which is not a nice thing, right? That's the alternative in some sense. But then you need to somehow have some sort of international agreement and do this together. Because if you don't, and I'm using this word with purpose, right? You end up with partition. You end up with two digital entities, let's say India versus Germany, whose laws are going to move away from each other. Because you're going to have to ban E2E in one country and not the other. And now you're going to have real trouble, right? So I think it's something that needs to be solved at a larger scale. I don't think you can solve it at a national scale, very honestly speaking. I hope we can, because the problems are real.
I think there's an interesting case study that happened just today, where the FBI and the Australian police had actually built this secure messaging app called Amar, especially for criminals, and seeded it that way. And that's how they were monitoring all the criminals' conversations for a number of years. And then they would keep collecting evidence through that app, which they built, which they made secure, and then secure within quotes, and then use that data, those messages against the criminals. And a similar thing also happened with EncroChat, where instead of enabling traceability, using analog methods of investigation, a number of police agencies in Europe infiltrated groups on EncroChat, which was this end-to-end encrypted platform only for criminals, and then started collecting information on them and started targeting their hideouts. But we have a bunch of other questions from the audience. There's another one.
Just one. Dr. Gupta mentioned about future. Yes. Section 69 of the Act provides for that. It provides that directions can be issued by the government to intercept, monitor, decrypt future messages. So that provision is there in the Act.
So that kind of prospective
yes, it's already provided
interception that. Okay, got it. But there's also the interception rules, the decryption rules, which has this caveat about to the extent possible, which has been interpreted differently by Facebook/WhatsApp and by the government in the courts, where WhatsApp, Facebook have argued that to the extent possible means as of today, and the government has argued to the extent possible even means architectural change. So how do we interpret that bit to enable that Section 69 proviso for prospective interception?
Just to say, because Section 69, Section 3 says that an encryption, that information has to be on your computer resource. So you can't change the architecture. Whatever is on my resource, like Dr. Gupta was mentioning, you identify Mr. Datar as a potential criminal. Now please monitor whom he's talking to please decrypt. So whatever information is on the computer resource, which is again defined in 2U of the Act, 2C of the Act, that you can do. but you can't. There's no direction that you must completely change your architecture for that purpose.
Okay.
If I could just quickly intervene there.
What difficulty the rule is, the rule simply says do this. Whether it's possible or not is your headache. That cannot work. Yeah.
It's not a technology. It's not a science paper that you're trying to make of whether a technology is useful or this or not. So this is the law of the land. They will have to agree to it. So how far? What is the middle ground? That's what is important. Even now, you realize that telephone records are kept for I think 1 month or 6 months by telephone operators, and if the investigating agency goes after that, obviously it cannot get this. So I'm sure these things would be sorted out over a period of time, and the point is, I'm very clear on this, that technology, the law cannot be subserving the technologies. Technology is to subserve.
Got it. Namrata, you wanted to say something?
And just a very quick take on Section 69 and the decryption rules. I think they do apply to decryption to standard encryption. So, for example, it would apply to a mail sent on Gmail, which is encrypted but not end-to-end encrypted. But like you mentioned, it does not, neither the section nor the rules say that you must develop a new technological capability to decrypt content. So WhatsApp chats would still be accessible provided they are backed up on a cloud or a separate computer resource that is not end-to-end encrypted. So I don't think under those there's still the power to for kind of prospective investigation on the platform itself, so long as it is end-to-end encrypted.
Okay, got it. And we have another question from the audience here. How can we ensure that in the future rules are drafted only in consultation with experts and relevant stakeholders, especially given what Mr. Datar said in his opening remarks, and Dr. Patnaik also pointed out that since 2018 there have been consultations, and practically every submission that I went through said that the traceability provision should be removed, and yet it was incorporated in a different format. So how can we ensure that? Dr. Patnaik, if you'd like to go first with this.
No, the point is the experts come and give their views before the commission, before the committees. But it is not that whatever the experts' views come, the other experts get to hear that. For example, in the data protection committee, the Joint Committee on Data Protection Bill, we have probably had 2,000 pages of submissions, and you know what the other person has. We had submissions going even beyond what the bill says, very stringent provisions, and people saying, of course, that there should be very less light touch regulation. So you have to balance everything, take the government's view into account. Government is not expert-less and headless, nothing. They also come with a lot of public policy implementation issues, which the experts may not necessarily be knowing. And everything is taken into account while finally, finally recommending a bill. And it's ultimately, again, the government itself, which takes a bill in the shape that it wants to go to the parliament, where it gets discussed once again and gets passed. So I think it is not that a group of experts views will completely overtake whatever the views of the others are, because people who are public policy practitioners, let's say the bureaucrats, the officials, the police, the investigators, they are also experts in their own right. So it is not necessarily the people who are the domain experts. Everything taken together is important. Whenever this balance is not struck or balance is not there, then we have problems, of course, and therefore the amendments come. Therefore they go before the courts. So the process is well laid out, and then, of course, if everything was so tightly done, then we wouldn't have had 101 or how many amendments to the Constitution or into any law.
Mr. Datar, if you want to make any
Yeah, I just want to comment. What concerns me is not only the data protection rules or the individual rules. Very often rules are just made. What I wanted to test was, before you made this rule on traceability, just as I expected, would it not have been better to start it as a pilot project? Start with a particular messaging service find out whether that messaging service can do traceability, what is the cost, what are the difficulties. As an expert like Dr. Gupta will say, it's mathematically impossible. Another expert may say, no, it's not so difficult. This is the thing. The third expert may say, yes, it may cost $100 million, but it is worth the social cost, because ultimately, if we can detect 100 cases of child pornography or rape, etc., it is still worth the social cost. At least some pilot project should be there. You introduce a guideline applicable to all, and then that creates a lot of problem because it's difficult to implement. That's the problem. Mr. Patnaik is right that the law, the technology has the technology to follow the law, but in certain cases, it is technologically impossible to implement the law. Then what happens? Then you simply say in India, no, we don't have end-to-end encryption in India. You pay the cost. The whole world has a facility, but because our law is like this, we will not be able to comply with it. That's again a choice which we have to make. But I'm only saying that again and again in so many, because I deal with so many issues, some kind of pilot project should be there. Some kind of do it on a trial basis. Find out if it is working before you before you enact such a rule. That's only my suggestion.
I think that's an interesting point, because the sandbox provision also exists vis-a-vis new technologies in the PDP bill. And the RBI allows for sandboxing new innovations. So there might be something to look at over there. Unfortunately, we have a number of questions rolling in, and there's a lot that needs to still be discussed, but we are running out of time. I'm deeply grateful to all our panelists, Dr. Patnaik, Mr. Datar, Dr. Gupta, and Namrata, for being a part of this discussion and for taking out their valuable time. What we can try to do is we can try and answer as many questions as possible, maybe on social media, maybe by getting in touch with the panelists after this. But thank you everyone for joining us today. And please stay safe.
Thank you so much.